I'm Patricia Cavanagh. I'm a psychiatrist. I'm currently working at CAMH in one of their ACT teams. For years I worked with the Toronto Western's IMPACT team. And I'm also the medical director at CAMH. I'll let Andrew introduce himself.
And I'm Andrew Bond. I'm the medical director at Inner City Health Associates, and my clinical practice is in the Dan Harrison Complex and George Street buildings.
And we both work with ICHA, and actually Andrew's medical director there now. I've been working in one of the shelters, Women's Res, for many years. And both of us, I think, have a lot of experience with psychiatric emergencies, getting people into hospital. I have worked a lot in emergency rooms, especially at Toronto Western in their psychiatry unit. So I hope that we'll be able to answer questions today. And we're going to say, please ask questions as we go along, or at least put your hand up. Maybe we will redirect you to another moment, depending on where we are in the presentation. But we'll check in with you about what kind of emergencies that you're dealing with, what kind of situations you've had to deal with, and try to answer your questions as we go. The handouts that I've sent around, I really sent the Form 1 and Form 2 out just so that you have something to look at when I'm going through those slides, just so you can read from them. If you don't want them, you can leave them behind, although it always helps. I tend to keep a Form 1 in my pocket. The Form 1 tip sheet is something that I made up for family docs, so you might want to keep it with you and hand it out to family docs, because it sort of tells you how to not make mistakes on the Form 1, the kind of things to have to emphasize, and it's a bit of a confusing document, so we'll get to more on that later. But here's our objectives for today. We'll do just a little bit, maybe 10 minutes at the beginning, just on a kind of an overview of mental health law, and then we'll talk about a little bit on the ORBs, CTOs, and what is a mental health crisis. That's when you get to say the kind of things that you need, you feel like you'd like some advice around. We'll talk about how to do Form 1s and Form 2s, and we'll talk about the role of police. So that's the plan. Okay, so mental health law in Ontario, Ontario's, like every jurisdiction has their own mental health act or mental health set of laws. It might sit in different acts. In Ontario, it's mostly contained in the Mental Health Act, the Healthcare Consent Act, Substitute Decisions Act, and the Consent and Capacity Board is one of the, an agency that helps to regulate, so that when people want to challenge one of the findings that a doctor may have made, they can take that to a Consent and Capacity Board. The panels are made up of lawyers, psychiatrists, and community members, and they'll review the situation. Won't get too much into the details of that, but they're kind of a presiding, regulating agency. I'm noting two things here, CLEO, Community Legal Education Ontario, and the PPAO, which is the Psychiatric Patient Advocate Office. They're great sources for information, and they both have really good websites and pamphlets and what have you that you can download. So I would really encourage you to look in those two places. You might know of other places, and there might be other places to find things, but those are two particularly good places to look for information around mental health law. The thing to keep in mind, in Ontario, we have particular rules. It's different in every province. It's different in every state. Ontario is it's actually widely admired, even though it causes us so much frustration, because it's got a lot of responsibilities and protections built into it, so that it takes very seriously the idea that you might be infringing on someone's rights, and it allows that person to have access to a way to challenge that. So this is endlessly frustrating when you're trying to get somebody well. But it is widely admired for the protections that it builds in. Some people think that it goes too far in building in those protections, and it's true that you can sometimes have crazy situations where somebody's hospitalized against their will for a year, waiting for things to go through the courts so that they can finally be found incapable and then treated, and then consent can be sought. And I think you might have covered some of that in a previous session if you did one on consent and capacity. But it is what it is, and it is widely admired, and it's complicated. You can also get access to the Mental Health Act and all of those acts, those regulations and rules online. I just want to touch on the Ontario Review Board. We're not going to talk much about that today. So when somebody is found NCR, or not criminally responsible, or unfit to stand trial for criminal offenses. That's all served by the ORB, as we call it. And we often will see people in our practices, knowing that you work with community agencies and what have you, you'll often see people who have criminal charges brought against them, and you know that they are not criminally responsible. They're maybe acting on delusions, or they're so disorganized that affected how they behaved. Not all of those people go to the Ontario Review Board. Again, this is sometimes frustrating because we would like to be able to get people help sometimes, and we would like to help them bypass the criminal justice system and get help. But lawyers will try very hard not to get people under the Ontario Review Board, generally speaking, because they are, at the point that they are found NCR, they are committed to a forensic hospital, and basically their situation is reviewed every year, but it's not until a panel of the Ontario Review Board decides that they should be released that they're going to get out from under that. So people can be into the forensic system for many years. They can be in the forensic system and given community privileges, and so you might know people who are under the ORB but living in the community. But very few of those people actually get under the ORB itself. So I just want to touch on that because that's something that comes up. Just to say a little bit more about that interface, the interface of mental health law and the criminal justice system, they don't fit easily together. I feel like these systems are often kind of clashing because they don't work easily together. We found ways to try to work together. I mean, one of the ways is the Ontario Review Board, which I was just speaking of. So remember that if somebody's hospitalized in a forensic hospital and under that system, that's really associated more with the criminal justice system than with the Mental Health Act and the laws that are governing the rest of that hospital. CAMH, for example, has a very large forensic program, but the rest of the hospitals kind of runs under different rules and is funded in a different way. Probation is another way that we will encounter, and you're probably familiar with people who are given as part of their sentence a probation order that allows them to have certain privileges living in the community. They don't have to go to jail or what have you, as long as they do X, Y, and Z. So judges won't tell people to take treatment, but they'll insist that they follow up with their doctor, assuming that the treatment will likely come of that. Or they have to report in a certain number of times or what have you. And so very often case managers and community workers can work with the probation officer and their clients to help people stay well and stay out of trouble. Also happens through bail when people before they are tried, but they're allowed to leave jail on certain terms. Again, we often work with bail officers to for all I know, some of you are bail officers, actually. I'm not sure, but you might be very familiar with these things. But these are ways that I think when we have patients who have mental health problems and they get into trouble with the law, we can kind of help them out and help them get better that way. The mental health diversion system and the drug court system are both programs that were kind of patched together, but people worked in the system and saw how badly it was going for people who really needed medical treatment or addictions treatment and weren't able to get it because they were getting into trouble with the law and getting into jail and just creating more problems for themselves rather than getting help. So both of those systems allow people to, if they have accumulated charges that are not considered too serious, not serious assaults, but lesser charges, and the charges related to their mental health in the opinion of the worker and the doctor, they can often go through this system where they have to check in with the diversion worker once a week or every few weeks or what have you for a set length of time, and then the charges might be dropped if they're attending to treatment and it's working in their favor. So I just thought I'd mention a few of those because those are things that come up in mental health crises and mental health law, and we might run into them as we have a discussion about these crises. And community treatment orders, also just want to touch on that. You probably heard about community treatment orders, and people often want to know, why can't they put this guy on a community treatment order? So usually it's done as an inpatient. It can't be done on somebody who's like has a new episode psychosis. It really has to be done on somebody who's been through the system a lot. Basically, at a certain point, you know what's going on with this patient. You can see that he, for example, he has a diagnosis of a psychotic illness. He has very poor insight. He keeps going off medication. He has a substitute decision maker in place. And we know what works for that person. So you can put them on a community treatment order. They can be released from hospital on the condition that they follow this plan. And once again, because this is under the Mental Health Act, they have a chance to challenge that and have a hearing and what have you. But it's very often a way to keep people well, and it's got a little bit of teeth in it. And so that's just a little bit about that in case you want to be working with an inpatient team and suggesting that to them. These are some of the rules around them. These are some of the things I mentioned here that can be put into a community treatment plan. The other thing that happens with that is if somebody fails to show up for an appointment or stops taking their medication or following the community treatment plan, we can bring them in, ask the police to bring them in on what's called a Form 47 or order for examination. Now I can have the patient brought to the emergency room, I can assess them there, or have an emerg doc or a psychiatrist assess them, and we can try to get back on track, or hospitalize them if that's what's needed. Okay, so what is a mental health crisis? Because that's really what we wanted to talk about today. We thought we could ask you, and we'll keep notes and try to hit on some of these things as we're talking today. In the realm of Form 1s or getting people into hospital or dealing with crises, do you have any kinds of situations you would like to tell us about? I don't want to go in depth into cases right now, but if you have any kinds of situations you could shout out to let us know, and we'll make sure that we hit them. When's the last time you were saying, God damn it, why can't we get this person into hospital? Or why didn't they admit him? Or how do I get help to this guy? So without getting too much into the details there, you're talking about somebody who's had multiple suicide attempts, family's still concerned, or the workers are still concerned that he's at risk, but he's discharged without a plan, a treatment plan, okay? Any others? People in the shelters, or people you meet in agencies? Yep. So somebody who's putting themselves at risk through a panhandler who's exposing themselves to the elements and getting frostbite. How do you intervene in a case like that? Yeah. It's a great situation. Sounds someplace where we can help. Yeah? Okay, so somebody who is at an agency or shelter, I guess, and is psychotic, agitated, you call the police, but the police release them on the street, violent. Okay, so what can you do in a situation like that? Okay, that's an interesting one because it involves the police who have come to help, but haven't given any sort of definitive help, just removed the person from the scene. Yeah, okay. Okay. Well, you know, our police are great. They work at the front lines of mental health all the time. Some of them find that very frustrating and some of them not. Some of them are really, really great and some frustrate us. I think on the whole they do great work and important work and they're a big part. So engaging with them and trying to solve those problems is an ongoing challenge. I agree with you. Okay, so the revolving door people. So this scenario is someone who has mental illness and also substance use problems, which are very often combined. And when they go to emerge tends to focus on the immediate issue, which would be the intoxication, maybe send them to detox, but they have ongoing mental illness problems. So, okay, well, we've got a span. I've got a variety of things there, and that's good to keep in mind the kind of questions you're going to have, but we'll be able to open up for questions hopefully as we go along here. So Form 1, which you have there, and that's what the tip sheet is about. It's an application for psychiatric assessment under the Mental Health Act. Good thing to know is that any doctor can do this. It doesn't have to be a psychiatrist or anybody with special qualifications. Anybody can do a Form 1. This is only the first step, and we can talk a little bit about this, but this is the first step which gets them into the emergency room of a Schedule I facility where then they're going to be assessed. So that assessment in Emerge can take up to 72 hours, 3 days. It could happen in 10 minutes. I mean, sometimes people say, it's obvious this person has to be admitted. Let's immediately put them on a Form 3 and bring them into hospital. Sometimes it takes a little while to figure that out. And increasingly, Emerge psychiatry teams want to do that in the Emerge rather than bring them onto the ward sort of to do the assessment. So if you can do that initial assessment in the emergency psychiatric unit, if you have one, that's the best. A Schedule I facility is just a place that's been designated by the government to be able to take these people, and the police will, of course, know which one or which ones are Schedule I. In downtown Toronto, I think everybody is except for sick kids, I think. Pardon me?
And women's.
And yes, that's right. Women's college used to be, and it's no longer. And sick kids, I think, is not a Schedule I facility, although it might have changed in the last few years. But anyway, the police know where they can take kids, what age they can be, and what have you. So, to do a Schedule I, as you will see on those forms, a doctor can use their own observations, but also other people's observations. And basically, they're working around these concepts. They have to be worried that the person is at risk of bodily harm to themselves or to other people, that they may be behaving violently to someone, or someone is fearing bodily harm from them, or they have a lack of competence to care for themselves. So that's pretty self-explanatory, I think, except for a lack of competence to care for self. The thing to keep in mind there is, this is usually, an example might be walking into traffic or eating something inappropriate, like food or like not food, like poison or feces, and the belief that it's something else, or yeah, so it's that kind of thing. And there's a little bit of some of these are what am I trying to say? Like they cover each other to a certain extent. But in your explanation on those forms, you can give the details. So this is an important part of the legislation, which is written on the form. But it says that you can do this within 7 days of having personally examined the patient. And the important thing about that is the doctor might see somebody in their office or wherever on Monday, and not on the next Sunday get information from their case manager or their mom that now the patient is acting differently. When you saw them in the office, they might have seemed fine, but since then they've become actively suicidal, or they've become extremely psychotic, agitated, violent, or whatever. So you can do it within 7 days of having seen someone. And that's what the form looks like, as you can see. The first part, the box A part, is about when you're worried basically about serious harm coming to the person or to someone else. And this is where you put in the details about why you're worried. So a doctor who saw somebody on Monday and said they were fine, they were calm and pleasant, and they said they weren't suicidal, and I didn't see any signs of agitation, will not be able to say much about that. They can say, you know, whatever they saw, but they maybe didn't see any risks of harm to somebody else. But later, mom reported that, or the case manager reported that, and that's really the basis on which they're acting. So that's what they have to emphasize there. My observations, I saw the person at baseline and then communicated to me by others. Mother reports that patient said exactly what he said, or somebody saw him doing this. I saw him walking through traffic, or whatever the case may be. You want to emphasize it. You want to be kind of blunt and stark about those things to help make it easy for people to make that assessment. But this is where you talk about the threat itself. You don't talk about their mental illness, their history of it, how many times they did it before. You talk about the current situation that's causing you concern. And then what they call the future test, just to be confusing, that's where you talk about the mental illness part. So you say, I'm of the opinion that this person is suffering from the mental disorder of a nature or quality that will result in harm to others or self. And this is why. My own observation, again, is what you know, and you can say, I've known this person for 25 years and talk a little bit about their history. Or facts communicated to me by others. This can be what you read on the chart. This can be what mother told you. This can be what police told you. That's where you put it. But you emphasize here the mental illness. because Form 1s are not for people, they're not for anybody who's going to do something harmful to others. Criminals go through the criminal justice system and you call police and get that taken care of this way. This is what we're talking about with mental illness. We want to be clear about what the risks are and then what the mental illness is, so that that's how you're going to help them make the decision in the emergency room. And after they do that and somebody is held in the emergency room, they're going to be looking at the same issues about risks to self or others and mental illness, but it's a different set of forms. A Form 42, I know that's one of the things that, Lara, you were mentioning as on the learning objectives for today, but I want you all to forget about Form 42s, because the hospital has an obligation to give people a Form 42 when they get there, and you'll see it listed on the Form 1, but we don't have to do it when we're bringing somebody in. It's really up to the hospital to take care of that. They have to give somebody a Form 42, which tells them you're being held at the hospital for the purpose of a psychiatric examination. You have certain rights. Actually, you have very few rights under a Form 1, because the rights kick in when they make a decision to admit you to hospital. But basically, this form allows us to bring people in and be examined to see if they need to come into hospital for longer. So don't worry about Form 42s. And then the B criteria, I'll just explain this and we can have a little discussion about it. The B criteria, when this came into effect, I think it was 1997 or something like that, they changed the Mental Health Act to allow us to basically intervene before somebody gets sick. So up until then, I found myself many times as emergency psychiatrist saying, I understand he's gone off his meds, I know what happened before, but there's nothing I can do about it because he's still pretty well and he can explain himself. And he's telling me he's going to take his medications, even though you're saying that he won't. I would say, like, he's going to have to get sicker before we can bring him in, which is a terrible situation to be in. And finally, it was addressed by this change in the Mental Health Act, so that now, under certain circumstances, you can intervene under what they call the box B criteria, or the B criteria. You can get help for people before they get sick. So you're worried about the same things, the way it's laid out before, about risks to self or others or serious impairment. But you're talking about this in someone who has a mental disorder and the same thing is happening now, the same that happened before. This is usually with a chronic mental illness, and let's say schizophrenia, chronic psychotic illness. They've been treated for this before. Treatment works. Like, we have a way to treat this person. They have shown improvement as a result of treatment. They're incapable of consent, so they don't have the capacity to make those decisions for themselves. Somebody else has consented to this treatment. They're suffering from the same thing now, and they're at risk to themselves. And you have reason to be concerned that they're going to become unwell. So then it asks you, as you'll see on the Form 1, to explain what the concerns are, a little bit about what their history is and what the concerns are now. You don't. In hospitals, they might, but you would then trying to bring somebody into hospital on the other terms of the form. And you can explain, even if somebody hasn't got extremely unwell yet, you can still explain why I think this person is at risk of becoming a risk to themselves or others. You can say, then that's where you would emphasize in the history. Every year, this person has a manic episode and ends up doing things that are dangerous to themselves, decompensating severely. So, yeah, you don't really have to worry about that. The hospital should be worrying about that. I mean, to do any kind of treatment, we have to get informed consent. That's just the law, and that's all enshrined in the Healthcare Consent Act. So a physician who wants to initiate a treatment, generally we assume that people are capable of consenting, but if they're showing some reason to make us think they're not, or they might not be, then we have to look into that more formally. And if they're not capable, we are obliged to get consent elsewhere. So it's prescribed in the law. You have to go through family members, and it tells you who to use first. That's spouse, parent, child, and then you go into sisters, aunts, second cousins, what have you. But it's all prescribed in the law. We know where to look. Or if none of those people are available, none of those people want to do it, then you go to the OPGT. But that's really up to the treating physician. And very often our folks, just because they end up in hospital so much, very often they burn out their families or they're estranged from their families. they end up having the OPGT involved, and that makes everything simple because you always know you can get them on the phone. They've got an emergency line, and it can be all quite easy to do that way. Of course, people are more fortunate when they have their families around them, and I always try to give families who are involved good feedback for how valuable that is, because we see so many people that don't have that. So, Form 1s, any questions about that? Yeah, you might want to get involved in this answer, Andrew. The situation that's been described as somebody who doesn't have a family doctor and is kind of isolated from the healthcare system, so they see different providers. I should mention here, I'm talking about Form 1s as only community providers using, but in fact people use a Form 1 in the emerge when people bring someone, police or somebody else brings somebody to hospital, and the feeling is we need to take some time to assess whether they need to be admitted to hospital or not. So you've got those 3 days that you can use under a Form 1. So that's a good point, that they're also used by physicians in the emergency room. But what do you do when you don't have a family doctor and there's nobody involved? Why don't you?
Thanks, Justin. Yeah, so I think it's a great question and far too common, unfortunately. So if you don't have a family physician or primary care provider or nurse practitioner who can do this for you, there's a few different things that you can do. First, you can have somebody go to a walk-in clinic. Even though they don't know you, they can fill out the Form 1. You don't have to have an ongoing historical relationship to do that. All of the stuff that's been described by Patricia here have been things that can be assessed fairly quickly and usually are pretty clear, especially if you have a case manager or someone escorting you to help provide some collateral information and help understand the context of what's going on. It's not ideal in a situation, but you certainly can do that. I think that we're going to be talking to about EDP forms and Form 2s, and there's some other options that you can use that we'll get into that I think are relevant too. So Form 1s are not the answer to everything. They're a useful tool for when you have them available to you, but and as Patricia was saying too, that the emerge can also do Form 1s, and sometimes that's a last resort option, and it certainly can be a way to go. One of the reasons why Inner City Health Associates has a minimum of ideally having somebody, a provider in our settings once a week, is the 7-day rule. It means that the likelihood that we have seen somebody within those 7 days in the settings in which we work is pretty high. So even if that person isn't there on that time, you may be able to contact that person who might be providing care in that setting. And it's certainly a way to arrange care to make sure that we have a bit of a safety net around the city, even when we can't be there all the time as much as we would want. It helps us stretch our abilities to support the teams that we partner with.
Yeah, Inner City Health Associates is an agency that has physicians, psychiatrists, and family docs mostly in shelters around the city and in a lot of different agencies and other settings as well. So I presume some of you will have encountered these folks, but exactly as Andrew said, when I go to the women's residence and staff are concerned about somebody, she refuses to see me now, or she's out when I'm there on Thursday mornings, I will try to see her at least for a little while, get some kind of an assessment so that they can contact me during the week. And when things go haywire, I can then fill out the form. She was fine when I saw her on Thursday morning, but since then, staff report that she bopped another resident in the kitchen or what have you. So, yeah, and you can try to see, so there's some people that I will just try to see once a week because things might develop. So there are some docs, when I was in my training, I'm like 60 now. When I was in my training, which is getting to be a long time ago, there was one doctor in the city, Robert Hading, who used to do these things. Good old Bob Hading, who's still working. And you could call him, and he would he was like the only doctor who was like a flying doctor. He would come out and see people just when you needed to get a form done. So a lot of people relied on him for that. I've virtually all my working life worked in things that do sort of outreach. Walk-in clinics are good if you can get the person to a walk-in clinic. Each-a-docs are good. Sometimes there's a program called MDOT, which is a program some of you will know about, that they actually will look for homeless people who are like living under bridges or in inaccessible places, living rough, and they can come out. And then you can also call the police in situations, but I'm going to talk a little bit more about how to get other ways to get people into hospital. Any other questions about Form 1s when we use them? Yes? One issue that I wanted, actually just more on that topic, there's not a lot of nurse practitioners who have expertise in psychiatry, but I know we are training them up. So we have some people coming through CAMH through the nurse practitioner program. And I think there's a desire to have more people working in that field, and maybe this will evolve. This is all legislation, like I said. Legislation is hard to change. It very often takes advocacy and a committee work, and it's hard to change these rules, these laws. One other thought, when you mentioned people coming into the hospital and they don't have the continuity, so nobody knows their whole story, it's always best, if you can arrange it, it's always best to take somebody to a hospital where they have some history, because then they can look back at the charts and you expect that that physician doing the assessment is going to have access to their old records. Right now we have Connecting Ontario, which is a system that allows any doctor in a hospital to share or to look at information from other hospitals. And it's still evolving, but it's fantastic. It's so much easier than what we used to have to do. We used to have to get these consents and then fax them off, and in the middle of the night have records sent over, and you'd have to wait for them, and it took forever. So now you can look at a lot of emergency assessments and consultation notes, discharge summaries, et cetera, online. Not everybody's used to using it. Not all of the hospitals share the same information, so I keep on getting like triage notes from UHN. I think this is not helpful to me. You know, when they take somebody's temperature, and like, that's not helpful. I want the emerge note, you know, like the one that says what the decisions were. But anyway, that's kind of a miracle, and it does make it a lot easier to get information from other hospitals and to keep track of medications people have been on and their substitute decision makers and all that. Okay, so we'll move on to Form 2. Basically, this is what to do. A Form 2 is what you do when you can't get a doctor to see somebody for whatever reason. They're refusing, they're hiding, they're stuck at home, you can't find a doctor, probably the latter. This is the other option that you have. And anybody can actually complete a Form 2. It's called a Justice of the Peace's Order for Psychiatric Examination. And what the mental health law around this talks about is information upon oath. So you basically have to go, in our case we would go to City Hall, Old City Hall, and line up at the Justice of the Peace office and get put on their list along with all the people who are getting bail orders signed and this and that signed. You wait to see the Justice of the Peace and you tell them the circumstances and why you think the person needs to be brought to the hospital. And so that is, you're called the informant in that situation. And you put your hand on the Bible and that sort of thing. I find that justices of the peace don't necessarily know a lot about mental health law. I mean, they're all, you know, well-meaning, but they don't necessarily know a lot about mental health law. So you sometimes have to explain to the person. They might say, well, did you see this person with the knife in his hand? And you say, well, no, actually, Mom saw them and told me about it, and that's what I'm telling you. And he'll say, well, no, you have to see the person doing it. You don't have to see the person doing it. So the Form 2 that I've given you, you can look at, tells you what to focus on. Again, we're talking about serious bodily harm to self or others, or an incompetence to care for themselves, and it has to be because of mental illness. So they will ask questions, and you should come prepared to explain. You can even bring a note, you know, that summarizes whatever aspects of their history you want to emphasize. But you want to be emphasizing the risks. That's what's going to make people act. I've been turned away from Justice of the Peace without a Form 2 a few times, but mostly I've been pretty effective in getting them. I find like junior members of the team sometimes get turned away. So I try to send, you know, in our case we have residents very often. If a doctor can do it best, or somebody who's savvy and who can sort of explain convincingly, but you don't always get it. Anyway, a family member can go to the Justice of the Peace, a landlord, a neighbor, a case manager, even a physician. I can't get to see the person, so I can't do the Form 1, so I'm coming here to ask the Justice of the Peace to do a form to bring the person to the hospital. And this, again, the same sort of things are at play, the time frames. Police have 7 days to bring the person in. The Justice of the Peace will actually hand you the form, and then you have to go to the whichever police division you need to use for that person. Or you can just call the radio room and they'll tell you which division to go to, or they will actually send a police officer to your house or your office to pick it up. Usually we're in the neighborhood and we can just take it to 52 Division or 14 or whatever and ask them to act on it. And just a note, when you're dealing with the police in those situations and you give them the situation, sometimes they ask a lot about their mental health history. You're not obliged to share that information with the police. They have what they need on that form. You want to make friends with the police, so I would try to share what you can, but and get their badge number. It's always good to get the badge number, because then later if you're saying, like, where did this form 2 go? We're waiting 3 days later and nobody's brought them to hospital anywhere. It's helpful to know who is the officer that you gave it to. And they won't be offended. No police officers aren't going to be offended if you ask for a badge number. So, any questions about that? Yes? All right, that's a good point. Yes. Somebody's making the point that emergency rooms will often ask for as much information as you have about the person to help them make their assessment. Because when you bring somebody in, the police bring somebody in on a Form 2, then the emergency doc assesses for a Form 1. And then they make their decision about whether the person actually is going to be admitted involuntarily to the hospital. But yes, it will help them if you know about their history, if you have pictures. I suppose the pictures tell 1,000 words. I'm not sure exactly where all the privacy issues lie around things like that. I'm not the expert on that, but it's true. Like, those things will be convincing. Yeah. And as much history as you have, and you are allowed to share that. As in an emergency situation, when you're bringing somebody to the emergency room for a psychiatric assessment, you're allowed to share personal information that you have pertaining to the individual. Any questions about has anybody here ever had to do a Form 2? Yeah? So it happens. Did you have difficulty getting them?
Getting the form?
Mm-hmm.
No, I actually was surprised at how easy I got it.
Oh, yeah. So it depends on the day and the person. Some people find it easy to get Form 2s, and I guess it depends a lot on the individual that you're asking.
Yeah.
How about?
I heard that it would have been challenging to obtain, so I was kind of surprised how quickly the
Yeah.
process was.
Yeah. I have been frustrated sometimes by having to wait behind all sorts of officers of the court who are seeing the justice of the peace for various reasons. They have restricted hours, so you should do a little homework before you go. Maybe call the old city hall and find out what the hours are and try to get in there in time, because you do sometimes end up waiting, and it depends on the individual how lucky you are in getting them. But. Okay, so that's another way to get somebody into the emergency room. Any other questions about that? Okay, I'm just sort of going through. I've done another slide here, but the A criteria, as again I explained, the risks of bodily harm or violence towards somebody else. And again, Form 2, I should make a point of mentioning this. The Form 2 also does have that set of B criteria, so that if you have somebody who is incapable, treatment has been consented to, they have a history of doing the same thing before, and you know perhaps they've stopped taking their medications or they're refusing to come out of their apartment, you don't have to wait till things get really bad. You can, if you can't get a physician in to see the person, you can go to the Justice of the Peace and get a Form 2 without them having demonstrated their risk of violence to others. So they don't have to be holding a knife to your throat for you to be able to intervene. So it's a little bit limited in the B criteria, but it's a possibility to consider. Yes?
When you say incapable, do you mean they have had to have a previous capacity assessment, or just they're deteriorating and not?
No, incapable in this sense means in the past they were found not capable of consenting to the treatment for their mental illness. So it's...
So even if they had a temporary SDM at some time, that would...
So really you're talking about somebody who is under treatment, somebody else has consented to it, and they're going off their treatment. That's usually the circumstances. So that you don't have to arrange for a capacity assessment, and that would have been done probably in hospital in those sort of situations. But it's that sort of situation when somebody, the so-called revolving door patients who have been treated, we know how to get them well, it's just how do we keep them well when they're out of hospital. So these are some things that that make it a little bit easier for us to do that. Now the role of police. This is the trickiest one. It should be the easiest one in some respects. And any examples that you have to discuss this would be useful. But the Mental Health Act states that where a police officer has reasonable and probable grounds to believe that, and here we would go with that list of concerns and risks that we've talked about in the case of the Form 1 and the Form 2, bodily harm to self or others, impaired competence to care for themselves. That the police can act to bring somebody into hospital. So I have called this the police have the authority to arrest somebody, but it's actually not arrest under the criminal code. I guess in the lawyers speak, arrest relates to the criminal code. It's not, they apprehend somebody onto the Mental Health Act. Anyway, if they're concerned, if they see somebody dancing in the traffic, if they see somebody who is at risk of frostbite or whatever, they don't have to get a doctor to come see them or case manager to go to the justice of the peace. They can actually arrest somebody right away. So when I give people advice about what to do with their loved one or their client when they get into an emergency, the first thing I say is if it's a real emergency and there's like an immediate risk of harm, just call the police, call 911, because they can do what they need to do. If we've got time, we can try to get a doctor to see them, we can go to a justice of the peace. But you can always just call the police. And I know, because I've been working at the shelter for 20 odd years, that police don't always come when you want them to come in those sort of situations. And I guess they have their triage, and it's a source of frustration, and this is why we have police ambulance liaison committees and things where we try to work those situations out. But the police do have the authority to bring somebody in, and that's what you were calling an EDP. So an EDP is the emotionally disturbed persons form. It's not a form under the Mental Health Act, it's a police form. That is what they fill out to explain why they're bringing somebody in, so that they've got good documentation of why they've decided to bring somebody in. They don't have to see the dangerous behavior themselves. It can be described by somebody else. They can find that the son is in the basement very calm right now, but mom says this is what he just did an hour ago, and they're allowed to arrest or apprehend someone on that basis and bring them to hospital for a Form 1 assessment. So good to know that they can do that. And that's kind of your first step in a real emergency. Do you have anything else to add to that about getting police involved? That's basically the route. So those are the routes that you can bring somebody to hospital if they're in a crisis, in an emergency. Any questions about that, or any anecdotes about the frustrations you've had because it didn't go this way? The 20-year-old, 21-year-old person maybe who has a history of suicide attempts or recent suicide attempts, that's a situation to think about where you might be trying to decide which route can I take here, or what advice can I give to the family. And I would always say, in these situations, they happen so often, people will call me and say, my son, I think he's using drugs, and he said something about suicide, I don't know what to do. So I'll try to find out which programs are in the area, or who you can talk to, or do I know a name, and what have you. Can you pay for private treatment, which is always, or often sort of smoother and easier for people who have the wealth to do that. But call police if you're in an emergency. Is like, if you're really afraid there's an imminent risk, you can call police, and that's something that I always try to make sure I tell people. You don't have to wait until he's actually holding a bottle of pills to overdose on, and what have you. I often will say with young people, you should try to go to Emerge yourself, because I think one thing that tells a young person is that we're taking this seriously. Family's taking this seriously. We want to get you help, and we'll do whatever we have to do. In that situation, if somebody's admitted to hospital and sent to the ICU and then released before you know it, and you don't know about all of the things that happened or what the plan is, I mean, normally somebody wouldn't be released without a plan, but you might not find out what the plan is. So and you can focus your efforts that way. But I usually do tell people to go to the emergency room just to start the process there. But then, in all these cases, if son refuses, if family continues to be concerned, they might decide to go to a Form 2 route, and then I would want to go, if I was taking my son in or getting police to take my son to hospital, I'd want to have everything together, handwritten notes or what have you about what the risks are, why I'm concerned, why this was almost lethal before, whatever about the circumstances that you can emphasize that will help them make a decision. And hopefully people don't have to be admitted to hospital. It's always better if you can get people help without admission, but sometimes not possible. Any thoughts or comments on that? The situation with a panhandler getting frostbite, I've seen a lot of people over the course of my career who have frostbite and have lost parts of toes or feet, hands, in that situation. And very often there's a psychotic illness and some sort of disorganized behavior and poor self-care underlying whatever is driving them, whether it's a severe addiction or whatever. Sometimes you'll find, I guess part of what you were saying is sometimes these people will bounce out of Emerge. They'll say, oh, that's, I don't know, Esmeralda, we know her, she's always like this. And you're in the position of having to say, no, I think it's different this time. And I've been on both sides of that, making the decision to discharge someone when the family or a case manager really wishes I would admit them, and trying to get people into hospital when I think they really need to be admitted. So I think, again, if any evidence that you can give, actually this person is missing part of their foot because this happened before, anything you know about their medication, their compliance, and their psychiatric history that would help. All of that information is useful to them. There are some people, for example, I saw one of my clients yesterday get off a streetcar and he walked right through traffic, and it was a busy corner, Ossington and Queen. It was really very busy morning rush hour traffic. But he did it sort of defiantly. And he has a psychotic illness and bad addictions, and he was going to the cash office and he had a mission. But he was walking, defiantly, looking at the cars. And it was dangerous behavior. I can't really say that it was delusionally driven behavior, or that was because he was so disorganized or stoned or whatever that he couldn't figure out what to do. So anytime I see somebody in traffic like that, I think, oh, does that person have to come to hospital? And in his case, I thought, very quickly I realized that, he doesn't. I don't think there's anything that we could do for him in hospital. I'm pretty sure he would just bounce out. He wants to go and use, and he's got a right, unfortunately, to go and use, or whatever. He's got a right to go and use. And I don't think that I could use that argument, having just seen him walk through traffic in quite a dangerous manner. On the other hand, if he, we saw him recently, and last year, I guess, in cold weather, and he had nothing but a T-shirt on, like his trousers, his legs in the armholes, in winter weather, and a little jacket. And I thought, he's got to come into hospital now. If he's so disorganized that he can't even, protect himself from 20 below weather, this would be a moment when we'll bring him in. Or the same guy has developed a terrible foot infection so that he can hardly walk. And, I've been able to see that. I might bring him into hospital then on Form 1 grounds, but basically so that he can get his feet attended to. Those might be reasons that I would be able to argue successfully that he should come in. But, we can't, it would be great if we could bring people in and convince them to stop using and get them into rehab programs that were fully effective. It's very hard to do, and I'm sure a lot of you have had experience with that. There's many, many steps between using and making the decision to stop, and all of the steps on the journey that you have to go to successfully rehabilitate from addictions. So even though we'd really like to, we can't bring those people in, even though they're desperate and doing bad things. They won't necessarily be helped by coming into emergency room. And that's what they're basically trying to decide in the emergency when they're deciding about voluntary admission. So Andrew, you might have some thoughts on this too. I generally go the route, over the course of my career, I've changed my approach. Now, I generally, when there's an assault or I am assaulted or something like that, I've never been seriously assaulted, but I would tend to go the route of reporting to police. Because there's no such thing as pressing charges. Like it's a term we all use, but we can't really force the police to lay charges. The police officer and their detectives will make decisions, and their crown, what have you, will make decisions about laying charges and how to proceed. And it's going to be based on the probable grounds for conviction and other things. And it depends on if the charge is petty or more serious and what have you. But I think that if they show up on the record in the hopes that one day somebody might look at this and say, whoa, this is serious. I mean, they haven't ever done anything that's seriously harmful, but they've had like 100 arrests and 55 near misses. Maybe it's time we took this seriously and actually requested an assessment for criminal responsibility. So they might go the forensic route. So this is controversial because it does have those, the degree to which your rights are removed when you go that route. But I sort of think that if the police are in a position of putting in those reports, that can help the person, advocate for the person in the long run. We can't decide what's going to happen. If you want to go, if there's enough evidence for a mental illness and you want to go Form 1 or Form 2 route, as we've suggested, then they will at least get an assessment in the emergency room, and they can decide, somebody can decide. Or the police are going to make that decision on their own if you just call them in an emergency. So I think you can try to push it one way or the other, but we can't actually insist that they lay charges or insist that they don't lay charges. They're going to kind of make that up themselves, make that decision up. Any other thoughts on that? Has anybody been in that situation trying to decide? Yeah, I mean, once somebody is in that situation, usually at the courthouse they figure that out. This would be a good candidate for diversion. Where can I get them services? And there's a lot of agencies, Cavanagh included, that have programs that help work with the diversion officers who are attached to the court and try to keep the person in treatment so that hopefully with the goal of this not happening again. So if we can use that, if somebody is committing crimes because of a mental illness and you can try to get them treatment that's going to prevent that from happening, that's a great outcome. And the diversion programs, I think, do a good job that way. Same with drug court. If they can get somebody who's motivated to actually get into treatment, great outcome. And I think it's great to cooperate with them, and there should probably be more programming around them. Do you have any thoughts on that?
Yeah, I had a couple. So one thing to also be mindful of going ahead is that, as people may know, the Ministry of the Attorney General is looking at having Community Justice Centre for Moss Park in the near future. That would add a new tool into the options for people who have high rates of recidivism around criminalization of poverty, homelessness, or substance use disorders. That will be a new piece. There's a lot still to be marked out about exactly how that'll work and what the criteria will be for the CJC, but it's specifically being designed as should the funding go forward, as around community health justice is the theme for this particular CJC for Moss Park. So that'll be another set of tools to think about. And I'm curious, because people have been very shy a little bit around, I suspect probably that a lot of people have had a lot of difficulty around forms and people at increased risk of threat or harm to self or others. Is it, maybe just as a quick nods, are people having a lot of problems in the community with having effective links of care, or has that not been the experience? Because I'm getting a little bit of the sense that maybe it's not, but I feel like it probably is. Is there, okay. Yes, do you have a question too there?
Yeah, it's like we can get them there, but I feel like a lot of them are sent back within like 5 hours. And
Perfect.
It's like,
Yeah.
Man,
Terrible, right? It's awful. Yeah, me too.
So
Absolutely.
frustrating.
It's, I mean, honestly, it's almost every single day in my practice. And I suspect probably yours too. So you guys are all being very kind and patient about this, but it's actually a really big thing. So maybe if it's okay, I'll just go through, because I know people have sort of held back a little on this. I'm going to push a little that I've come across about 3 major kinds of structural challenges that lead to things not working out so well. And then you guys can tell me if it sounds about right to you as well, or if there's other things that maybe we're missing, just to maybe drum up a little dialogue on it. Because I think this is where the meat is. I think that Dr. Cavanagh's explained, I think, really well how things are supposed to go. And then we bang our heads saying, why isn't it working the way we think it's supposed to work? And it happens all the time. So one is around criteria. So why it's so important to have gone through the criteria like Dr. Cavanagh has done is that the hospitals and the psychiatrists on the other end, or the emergency physicians who are receiving the forms, have to follow the criteria. And so there's a couple places where things go off. One is that always remembering that despite we're talking about behaving in a way or threatening around self-harm or harm to others or violence or competence to care for herself, it has to be related to an underlying mental illness in a way that is demonstrably connected to the provider who's assessing them in the emerge, either the emerge doc or the psychiatrist. So people do all kinds of really crazy things that may or may not be able to be connected directly to that mental illness. And if it's not, then the form won't stand. And so even if they think and they agree, yeah, this is nuts, and this person's gonna have, like, there's gonna be a bad outcome for themselves or somebody else, they may not be able to do anything about it, even when common sense feels like someone should do something about this. That's one really common one. They're really bound by those criteria. The other is communication, and that came up, I think, earlier around what kind of information that the community side is providing to the hospital. Because ultimately, applying those criteria means you have to have information to apply them in, right? So if you don't have the information, even if it was there, but you don't have the info, then you may think that the criteria don't apply. So our job, partly, all of us together, is to make sure that we provide as much useful information that we can legally under HIPAA to provide them. Usually that means anything that you have seen or observed. Just pictures are a little bit more careful of people's places. You can ask their private, or you can ask their permission. I've asked people in the middle of a psychotic disorder, can I take pictures of your place? And like, yeah, sure, whatever. And they go off and I take the pictures and send it. So you can do that, but just you do have to watch the pictures piece. But as much information as possible. So I recently, within 3 hours ago, had to do a Form 1. And I completed the Form 1, wrote a 2-page letter, called the emerge doctor, the triage nurse, the psych, the MESA or the psych emerge nurse and physician, all within a 1-hour period. It takes a lot of time. But that communication helps so much. If you think this person needs to be in hospital and might need to be admitted, it is worth doing that kind of advocacy to give them everything. Also providing my cell phone contact, the contact of the case manager as well. So really as much information that is useful as possible to really make your case, because that's what they're going to be going on. Because generally speaking, they're busy places. They've only got X amount of time to be able to do their assessment. So helping them to work with us is really, really important. So that's the communication piece. The other is systems of care. So ideally, if you have the right information, they do meet criteria, but then we look at it, and yes, they have an underlying mental illness. Does coming in and actually being admitted, which is often what we think is necessary in the community, are they going to be able to offer something more than what might be able to be offered in the community? And sometimes, even though we think that on the outside that they must be able to, sometimes it's not necessarily so clear on the inside of that. And so they might do an assessment but say, we're going to try a community outpatient follow-up care plan. We might have disagreements over whether or not that was a wise decision, but it's not a totally uncaring or unthoughtful decision. That oftentimes it's actually a lot of thought trying to figure out, can I actually help this person through an admission? Sometimes admitting people makes them worse. And so they have a lot more information too on their end that they may see. Every time this person gets admitted, they decompensate. It gets worse. And that actually is a thing that happens with people. And so I may not know that as a community provider that that's the case. They have Connecting Ontario and all the other access to information that I may not have. And so ideally, again, closed loop communication would be very nice. If that was the case, at least we would get some information saying, this is why we didn't do that. And there are some pieces that we need to work on as a system to improve our communication flow. But I think there's a lot of pieces that happen out of mutual misunderstanding and also a certain amount of mutual lack of knowledge about just how difficult things are in the community and how difficult things are in the hospital and the kind of challenges we mutually face. I think that's partly why this seminar series started in the first place. And I think it's really important to sort of draw out these things. So I suspect all of you have had some serious problems. We have a lot of work to do this better. But hopefully going through some of this information has been helpful to kind of get some of the mechanics of it and some of the places where things go off a little bit. If you can focus on especially the criteria and the communication and then trying to, when someone ideally is saying being discharged from hospital and we think it's a terrible idea, to at least try to make a connection, even if it feels like it's like totally impossible to connect in time. And it may be fruitless in the sense of changing the decision, but it may help understand why that decision was made, and then how that, what do we have to do differently in the community to try and help, and maybe try and get our colleagues in the hospital to help us out a little bit more. So for what it's worth, does that sound like it sort of speaks to people's experience of some of the challenges? And are there things that I've missed in that missive rant? Anything missed there?
I really agree with the idea of a letter, and knowing that from the inpatient side or the emerge side as well. If somebody comes in with a letter from a family doc or case manager or whatever saying this is what's going on and with contact information, that's very helpful. And I give out my cell phone. I've put some tips on that tip sheet about what parts to emphasize and trying to connect, as Andrew is suggesting. It can make a big difference. If you can actually talk, has anybody here ever talked to an emergency doctor? Exaggerating. But if you can actually talk to the emergency psychiatrist, make a contact, or when somebody's on the unit, make contact with them. If you can show up, if you're with an ACT team or a case management team or whatever, and try to connect with them there, they really appreciate that. They know that there's a plan in place. Also, if you have a goal for the admission, we would just really like to get this guy on a CTO. We have a doctor who can supervise it. He's got a case manager. We'd really like to get him on a CTO so we can try to keep him well. Or we really need a capacity assessment done for finances or whatever. If you have a specific goal, we need to get his feet taken care of. We know he's going to go back to using and living this very dangerous lifestyle, but he's got a foot infection that's progressing. Things like that are very helpful. Put your cell phone number on it. That's a good thing. Yeah.
Actually, I have another question.
Sure.
Have people tried to either talk to a provider, go to a JP or Form 2 for someone who has behavior related to substance use itself independently of an underlying mental health condition or mental illness? Has that been an experience people have tried? Either someone's, off their head on crystal meth, doing all kinds of crazy, terrible things, and then tried to get a Form 2 or a Form. Has anybody tried to do that here? No? Okay. So it's something that's, sorry. Where is the one?
Form 2, like a Form 1, like
Yeah.
getting a form for 72 hours.
For sure.
Yeah.
Was that successful?
Yeah.
Yeah. So unfortunately, the case law that we're aware of it, so we have some addictions teams and some legal teams looking at Mental Health Act and substance use disorder. There's not existing case law around successful dependent defense at consent capacity boards around using certainly Form 3s. Form 1s is another matter, but certain people have used them. The one exception around this is around people who are using substances in a way that is seriously affecting an underlying medical diagnosis. So say you have infective endocarditis, which is infection of your heart valves as a result of an intravenous drug use, and you are using all the time and can't get organized enough to actually get some help and you're going to die, you can use a Form 1, and there have been people who have successfully implemented Form 3s for someone under opioid use disorder as the primary diagnosis to get people treatment for their endocarditis, for example. So there are some early emerging ways to use that in the context of substance use disorder. It is still pretty new and not a lot of case law there. But that is something that we've had requests from community saying, I've got somebody using all the time, they're not eating anymore, they're starving, they're wasting away, I'm really worried for their lack of ability to care for self, competence to care for self and their safety. And it's a valid concern. There's just not a lot of experience around having that done effectively and whether or not the admission can actually be successful as an intervention as well as the other thing. But those are things that are out there.
Just to clarify, a Form 3 and Form 4 are under other forms under the Mental Health Act that we use to keep people on a psychiatric ward for once they've been admitted, so out of the emergency room and onto the unit. They will first be put on a Form 3 for 2 weeks and then on Form 4s, which lasts a little longer. And if it's a very lengthy admission, which it isn't very often at most general hospitals, then you go to Form 4s and they have a right to hearing, and you can have a lawyer represent you and try to advocate for certain things. But but on the street, you don't get too involved with those. Go ahead. You know, I mean, there are some people who are almost permanently certifiable. You just, like, there's no point in doing it because you know that they'll just bounce out of the emerge and they're getting more angry and you don't want to alienate them and all those things. So it might be a situation like that. And you know what, I would suggest maybe working with the hospital, try to find whoever's in charge of inpatients and saying, I'm in this situation and this is what I'd like to do. I know that I can get a Form 1 or 2 done. I can bring them in, but I'd really like to see that they get some help. And you know, everybody has to work together. I've been in that situation where you've kept somebody in and then suddenly one doctor overnight or on call or whatever just discharges them and the whole plan went up in smoke. But I think communications is a lot of what you can do. It's very, I mean, I think we all have to also give ourselves a bit of a pat in the back sometimes because it's very hard to help these people and hard to advocate for people who sometimes stuck in these self-destructive kind of addictions especially. So the system isn't designed to make it easy for us. But the system's designed with all these protections, which are also very laudable in other respects. So, anyway, questions, comments, stories? Stories from the field? Okay.
Thanks so much, everyone.
Yeah, thank you very much. Yep, bye-bye.